Good afternoon, everyone. Thank you for joining today's online talk. Before we begin, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on a bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody, and thank you for joining us for today's online talk entitled Resolving Disputes at the Strata Management Tribunal. My name is Abraham Kwa, and I'm a pupil with Maweng Kwa and Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Kwa and Associates is a mid-sized law firm that was founded in 1985 by Datuk Maweng Kwa. Our able team today comprises of 33 lawyers and a support team of 29. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department including litigation, adjudication, and arbitration, a dedicated employment industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which are also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. We have two speakers for today. Carolyn will be speaking first on the pros and cons of the Strata Management Tribunal and how to file and defend a tribunal claim, while Jasmine will be speaking on enforcing a Strata Tribunal order and challenging a Strata Tribunal decision. We will then conclude with a Q&A session. Now, allow me to introduce our speakers for today. First, we have our Caroline Ng, who is an associate in our dispute resolution, employment, industrial relations, and Strata Management departments. Carolyn graduated with first-class honours from the University of West England in Bristol and was admitted to the Malaysian Bar in 2022. At present, Carolyn is involved in the areas of practice including general litigation, joint management body JMB, and management corporation MC disputes, employment matters, and intellectual property. Moving on, we have Jasmine Wee, who is also an associate in our dispute resolution, corporate, individuals and families, and employment and industrial relations departments. Jasmine graduated with a Bachelor's of Law Honours at the University of London and is currently involved in the areas of practice including the laws on employment, corporate litigation, strata, adoption, citizenship, and immigration. Jasmine regularly provides advice to clients on various Strata Management Tribunal claims. And without further ado, I will now pass the floor to Carolyn to begin our talk for today.
Good afternoon, everybody. Thank you so much, Abraham, for that very generous introduction. My name is Carolyn. I'm an associate with our Strata Law Department. As Abraham has mentioned, I'll be speaking on two parts today: pros and cons of the Strata Management Tribunal, as well as how to file and defend a tribunal claim. I'll be starting with the pros and cons, but before I get into that, I just thought we should have a brief introduction of what the Strata Tribunal is and what it does basically. So the Strata Tribunal is a legally recognized body which handles disputes related to strata management. Later on, I'll go into the sort of claims that can be done, or examples of the types of claims that can be done in the tribunal, as well as the sort of orders that the tribunal can give. But up to this point, what we need to know is that it handles strata management disputes, but there is a limit of up to 150,000 ringgit. So the limit of all claims must be below that amount. Limitation does not apply to the tribunal, and the list of matters that can be handled by the tribunal is already provided for in the Strata Management Act in Part 1 of the 4th schedule. So it's a very detailed list, but I just thought that we will go into some common issues that are dealt with in the Strata Tribunal. So one of the main things that we see happening in Strata Tribunal are disputes on costs or repairs in respect of a defect. So for example, if you have interfloor leakage and you have gone ahead and fixed it, but you want to dispute who is supposed to make payment for such repairs, you can handle that in the Strata Tribunal. Claims for recovery of outstanding maintenance charges and sinking fund contributions. This is mostly for management corporations or JMBs who are collecting maintenance charges and sinking fund contributions. And where owners or proprietors do not make such payments, you can also claim for that in the Strata Tribunal. Claims for an order to convene a general meeting. Claims for an order to invalidate proceedings of a meeting where provisions of the SMA has been contravened. And claims to compel a developer, JMB or MC to supply information or documents. So these can be things like audited accounts, management accounts, etc. So here we look at a list of who can actually go to the Strata Tribunal. As you can see, it's quite a long list. It includes almost everybody who is involved in the development, from the developer to the purchaser, proprietor, JMB MC, a sub-MC, a management agent, and any other interested person. But for any other interested person, you would need leave of the tribunal. So the types of orders that the tribunal can give are listed in Part 2 of the 4th schedule. This is also from the Strata Management Act. So as you can see here, this is directly a screenshot from the Act itself. You can order to pay a sum of money. So that's things like what I mentioned previously about the interfloor leakage, who makes the payment. So tribunal can make a decision on who is the one who should make the payment, who has to pay the sum of money. Second is order the price or other consideration to be refunded. So if you've gone ahead and paid for that repairs already first, someone else may need to reimburse you for those payments. Payment of compensation or damages. Tribunal may order rectification setting aside. This is for bylaws. Tribunal may order for costs to be paid, may order for interest to be paid on any sum of monetary award, may dismiss a claim. They can also make an order of which it has the jurisdiction to make under Part 1. So Part 1, just now as we spoke about, is what matters the tribunal can deal with. So now we'll go into the actual pros and cons of using the tribunal, Strata Management Tribunal. So the main point of having the Strata Management Tribunal is basically to make the whole legal process faster. It is a faster method of dispute resolution as compared to if you have to file a claim in the High Court every single time you had an issue with your neighbor or your management, or if the MC has an issue with one of the owners or proprietors not paying up their fees. The High Court process, the actual court process in general, is known to be a bit tedious, very long, very difficult process. So the point of the Strata Tribunal is to shorten it, make it more easily accessible for people. So here I've written within 60 days of the first hearing date is when the tribunal is supposed to give their award. But this is only where it's practicable. As you can imagine, some of the issues that come up to the Strata Tribunal can be quite complex, would need maybe multiple hearings, would need experts to be appointed, would need reports, etc. So only where it is practicable, then the award will come out within 60 days of your first hearing. The second pro here is less cons. I'll be showing you a table of fees later, of the filing fees that are applicable in the Strata Management Tribunal. In the court process, for almost every document that you file into the system, there's a payment that needs to be done. So considering that there are less payments here would say that it's a cheaper option, slightly. Third one is self-representation. You do not, and actually you cannot have legal representation in the Strata Tribunal. You can apply for legal representation. However, this can be quite a tedious process, as it may not be allowed. It's easily accessible because from what we know, from what we understand, actually, if you go to the tribunal and you go to the front desk, you make an inquiry, how do I do this? How do I file my claim? They are very helpful because this is meant to be for the layman to do themselves. So these are the fees that are involved. This is just example, but this is, of course, the actual fees that need to be paid. Filing of statement of claim if you're a resident, for residential matters, 100 ringgit, for commercial, industrial, 200 ringgit. Almost for every document or every form that you fill, you would need to make a payment with it. Now, the cons of the Strata Management Tribunal is that there is limited jurisdiction. As I mentioned just now, it is an exhaustive list of things that they can deal with, and it has to be below 250,000 ringgit. The second is that it's difficult to get legal representation. So what if your issue is small enough to be in the Strata Tribunal, but complex enough that you feel that you need a lawyer to represent you? That is when usually sometimes claimants or even MCs run into that issue. So what you can do is you can make an application, like what I mentioned just now, you can make an application, but there is a test that you need to fulfill. The tribunal, rather, the chairperson needs to decide that there is a complex legal matter to be dealt with. And if you do not have legal representation, you will suffer financial consequences. And only if they are satisfied that there are those two things in place, then they will allow you to have legal representation. And if one party is allowed legal representation, the other party will also be allowed to have legal representation, because that's the only way that it's going to be fair. And the final con is that sometimes there may be issues with enforcement. I believe that Jasmine will be speaking more on this later, but you will see why, even though it may be a quicker resolution in the tribunal, if your other party, your proprietor or your management or whoever it is doesn't want to comply with the award, then you might have to end up going to court anyways. Now we'll go into the technical portions of how to file and defend a Strata Tribunal claim. For a filing of a claim in the Strata Management Tribunal, you start with what is called a Form 1 or a Borang 1. This is what a Borang 1 looks like. It can be done in English or Malay. Usually that is not an issue. So you have here the front portions. So as you can tell, it's separated into the top portion and the bottom portion. The bottom portion is the portion that will be filled by the claimant, whoever that may be. So you need to provide details of who is claiming, your relevant identification, address, who you want to be named as the respondent, etc. When you file this in to the tribunal, they will fill in the top portions, give you a case number, in what state and where this matter will basically be dealt with. So this is the continuation of the form. Butir tuntutan is the details of your claim. Tuntutan is what do you want, your prayers basically. What do you hope to achieve from filing this claim in the Strata Tribunal? Now, usually what happens is that sometimes if it's a particularly complex matter, this might not be enough space, that's fine. What we do is we will list it out, a document, and then you will just attach it to your Form 1. But when you serve this Form 1, you need to make sure that the details of your statement is also attached together with it. The bottom portion here is details, so you would need to sign it or thumbprint it, as well as put in the date. This portion is for the Strata Tribunal to handle. So these are more of the technical portions of it. You need to provide a statement. You need to detail the dispute. So who is involved? What kind of problem is this? Is this an interflow? Is this a payment of your funds, your singing fund contributions, your maintenance fees? And what kind of damages are you seeking for here? You can provide supporting documents, contracts, emails, correspondence, photographs, if it's like what I mentioned, interflow leakage, to show, oh, the leaking is coming from my ceiling. It's definitely from my upstairs neighbor, things like that. So when you have prepared your Form 1, you need to print out 4 copies of it. You need 4 identical copies, and you need to sign on every single one of these copies and give it to the Strata Tribunal. The Strata Tribunal will then give you back 2 of these copies. 2 is for the tribunal to keep. They'll give you back 2 copies, and those 2, 1 will be for you, and 1 must be served to the respondent. Serving to the respondent can be done by personal delivery. You know where they stay, you know which owner needs to pay you outstanding funds. Knock on their door, give it to them. A registered post to their last known address or attaching it prominently at their last known business address. This is for filing of the Form 1 and the technical claims involved. Now, what happens if you are on the other end and you receive a Form 1? Then you will need to defend it by way of a Borang 2. So this is you replying to the Form 1, Same thing, you need to fill in the details again. Who is the claimant, the personal details and everything else. Same thing at the top as well. It looks the same. It's just that it's named differently. And here, similarly, you have your space to put in your statement of defense, and this is for a counterclaim. Same thing. What a respondent can choose to do is you can say, I admit to the claim, find that there's no issue. Usually, it's not that straightforward if we've ended up in the tribunal anyways. Or you can provide particulars on why you are disputing the claim, or provide particulars of a counterclaim. Must be filed within 14 days. So basically, from the day that you receive the Form 1, you have 14 days to file your Form 2. Must be signed or thumb printed is filed by individual. This is what I mentioned previously. It's either an individual or an authorized person. Similar to the Form 1 just now, you provide 4 copies to court. They'll give you back 2 copies and you're supposed to serve one of the copies on the claimant. So before I go into the Form 2 here, just a side note that in the event that once you have served it on the claimant, what will happen then is usually you will receive a letter from the tribunal letting you know when your hearing date is going to be. Okay, so let's say there is no Form 2 filed, so there's no respondent here. Or rather, what if I show up on the day of the hearing, the respondent is there, but they've never filed the defense? What can the tribunal do? So in this situation, the tribunal can choose to either grant an order anyways, or adjourn the hearing to enable the respondent to file its defense, or we say we do it now, allow the respondent to submit his defense, and then proceed with the hearing. At the day of the hearing, if both parties do not attend, the case may be dismissed, or maybe they'll adjourn it to a different date. That's completely up to the chairperson. If only one person is in attendance, only the claimant or only the respondent can proceed with the hearing, you can adjourn it to a different date, or the tribunal can choose to grant an award. And in making this decision on what to do, what are the next steps, the tribunal will consider the representations made and submitted by parties. So this will be your borang 1 or borang 2, the tuntutan that you have made, or the dispute to the claim that you have made. Now, in the tribunal, usually we don't go into things like written submissions. Usually, the tribunal will decide in accordance with the provisions of the law that's available to them. And they'll look at the circumstances and they'll apply the law. Very rarely will the tribunal, unless they feel that there is a need for you to do, ask you to file written submissions. Other applications that can be done, these are known as interlocutory applications. This must be done by way of Form 14. So examples of this is like what I mentioned previously, an application to be legally represented, application for reference to a judge of the High Court on a question of law. So let's say you have a claim, you think that it's complex, there is a certain portion that is very legal, and you think that you need a High Court judge to be able to decide on that matter. You can ask for it to be referred for that question of law. You can make an application to adduce documents, so you know that the other party are in possession of these documents. You feel that these documents are necessary for this matter to be heard and decided upon. Either you or the other party or the tribunal itself can order for these documents to be adduced. And the last example here is an application to appoint an independent expert. So similarly, this can be done by either the claimant respondent or the tribunal themselves on their own accord. So independent expert here is someone who knows or possesses relevant knowledge and experience related to the matter. So this is for more technical matters, especially maybe when it comes to things like interflow leakage, where it's very technical. Maybe you need someone the expert may have to be a plumber, a technician, to come in and to decide fully, properly, whose fault is it, where is this leakage coming from, what's going on here. And 3 copies of this expert's report will be submitted to the tribunal. So let's say your opponent, your respondent or your claimant, whoever it is, has applied for an expert to be appointed. Tribunal has allowed and said, yes, I need an expert's report to make a decision here. But when the report comes back, you say, hey, I have a few questions about this. Doesn't look right. So what you can do is you can apply to cross-examine the expert. Look at the report. You say, hey, how did you come to this decision? How was this decided? How was that decided? Things like that. So basically, throughout the process of the Strata Tribunal, it may not be as simple as Form 1, Form 2, hearing, and we're done. In between, if there is a need to do, you yourself as the claimant, respondent, or even the tribunal can make all these interlocutory orders that might make it more expedient for this matter to be heard and decided upon. So that is for the filing and defending, as well as the basic processes in between of a Strata Tribunal claim. And I will now hand it over to Jasmine on the other end of side, which is if once everything is done, hearing is done, decision is made, how do we enforce it? Thank you, everybody.
Thank you, Carolyn. Okay, I will be talking about enforcing a Strata Tribunal order as well as challenging a Strata Tribunal award. So we'll start with enforcing a Strata Tribunal order. According to Section 120 of the Strata Management Act 2013, a tribunal award shall be deemed to be an order of a court, and it can be enforced accordingly by any party to the tribunal proceedings. If the tribunal award has not been complied with, then the tribunal will send a copy of the award to the relevant court, and the court will then cause a copy of this award to be recorded. And as far as methods of enforcement go, you have a number of options. So of course, I'll elaborate further later in the talk, but we start off with service of the award, notice of award non-compliance, recording in the civil court, letter of demand, civil execution proceedings, and lastly, criminal proceedings. So usually what we do is these go by steps. So you can jump to, say, you want to go straight to a letter of demand, you can do that, but normally what we advise is to go through these one by one. They vary in terms of intensity. So as for service of the award, the tribunal has a statutory duty, as I mentioned earlier, to serve a copy of the tribunal award to any and all parties that are involved in the suit. So a successful party can also take it upon themselves to serve a copy of this award on a non-complying party to demand compliance with the terms of the award. Upon service, the non-complying party's acknowledgement of the receipt of the award should be obtained. So usually what this means is, let's say you go to the non-complying party is a company. You go to this person's company, you serve them a copy of this, and you have to get them to sign or note somewhere that they have received it. Notice of award non-compliance, otherwise sometimes it's called an INCA award. So upon serving this award to a non-complying party, and in the event the party still chooses to not comply, then the successful party can prepare and should prepare and submit 3 copies of the notice of award non-compliance and also 5 copies of the award itself, and you have to submit this to the tribunal. So recording in the civil court, if that doesn't work out, if that's not enough to push the non-complying party to comply with the tribunal order, then the tribunal itself will forward the copies that you sent in earlier. The tribunal will forward these copies to the magistrate or the sessions court for it to be recorded. In order to determine whether or not it goes to the magistrate or the sessions court, they will see the monetary sum. So a recording of an award will have the effect of the civil court as registering the award as a civil case. So it'll be as if you started filing in the civil courts instead of the tribunal. And this will confirm the award itself as a court judgment. So any debt arising from the award, what this would mean would be usually people file claims in the tribunal for non-payment of maintenance charges or any sort of charges. Sometimes a tribunal award has no monetary value. You're just seeking for declarations of a certain something, but either way, it's the same. So any debt arising from an award will then become a judgment debt. And the tribunal will provide written confirmation to all parties once the award has been recorded in the civil courts. And we move on to a letter of demand. This is, I would say, one of the mildest forms of steps that you can take to enforce your tribunal award. It is the cheapest. There are cons to it because there is no legal obligation for a non-complying party to comply with whatever you're demanding in a letter. You can put whatever you want, but that doesn't necessarily mean that you get what you want. So after recording the award in the civil court, it can be enforced by way of civil execution proceedings, as I mentioned earlier. It's of course advisable to issue a letter of demand first, start off small. And usually this is enough to push someone to start complying, because you threaten someone with legal proceedings, nobody wants that, or at least I would hope so. So you give notice that civil and criminal legal proceedings can and will be commenced against the non-complying party if the terms of the award are still not complied with. If the non-complying party eventually comes around to complying with the terms of the award upon receiving a letter of demand, then further legal proceedings and costs will be avoided. It will save you a ton of money. And as for the real civil execution proceedings, there's also a number of ways that you can go about this. Of course, there's judgment debtor summons, garnishee proceedings, a writ of seizure and sale, winding up, which is if your non-complying party is a company, or bankruptcy if they are an individual. So just to give you a little more of a general view of what these would entail, for judgment debtor summons, it's issued by the court and it's to be served on the person that is doing the owing. And this will compel them, the debtor, to appear in court, and they'll be forced to provide information on their assets and what can be disposed of in order to settle any sort of judgment debts. And we move on to garnishee proceedings. What this is would be when you know that the person that is owing you the debt has money that is to be paid to them by a third party. So take, for example, the person doing the owing is a contractor and they have recently they successfully lobbied for a project and somebody is about to pay them. So when you get a garnishee proceeding, when you get an order, when you're successful, what happens is they will attach to the money that is about to be paid to the debtor, and that money will go to you instead of the debtor. So a writ of seizure and sale, which is also pretty self-explanatory. This deals with movable and immovable property. Whatever you can recover from your debtor, it will basically be liquidated, sold, and you will get the proceeds, whatever you get, whatever you're owed. The winding up of a company, of course, is just if the company is the opposing party on your end, you wind them up and you have to meet the winding up threshold, which I believe if they're unable to pay the debts, if the debts is up to 10,000. And as for bankruptcy, is for an individual, it's the same as the winding up. You declare them bankrupt if they can't pay. Usually when this happens, people will write in to ask that you withdraw because nobody wants to be declared bankrupt. So then they will usually comply. If after all of that, which is being quite generous to enforce a tribunal award in the civil courts, and the fees to enforce in the civil court can cost anywhere between 5,000 to 8,000 ringgit. This, of course, depends on the lawyer that you are engaging. So after all of that, there's still non-compliance by the other party. You can go through these criminal proceedings route, which in my opinion would be the most extreme. So this is also a fairly simple process. The complainant, let's say you are the winning party, you can make a complaint to the Commissioner of Buildings against the non-complying party's non-compliance with the award. And you can do this together. If they can run together with your civil execution proceedings, it's not a problem, because failure to comply with an award is a criminal offense under Section 123 of the Strata Management Act 2013. So for criminal proceedings, if the non-complying party is found guilty and they are convicted, this person can be liable to a fine that does not exceed 250,000 ringgit or to an imprisonment term that is not exceeding 3 years or both. For continuous offenders, there will be a further fine not exceeding 5,000 ringgit for each day of non-compliance. And the Commissioner of Buildings has the jurisdiction to investigate and also prosecute the office. So what this means would be when you file any sort of complaint to the Commissioner of Buildings, they will, and they are also obligated to run their own internal investigation to find out. So importance of understanding all this is once you understand how to register and enforce an award from the tribunal, it will ensure that successful parties are able to enjoy the fruits of their awards. So non-compliant parties will then be held accountable, and this will also allow parties to take appropriate legal action against non-compliant parties. Clearly, they cannot get away with it like if you're in the wrong. So this will allow the strata management system to operate fairly and effectively. So now I will talk to you about challenging a strata tribunal decision. Say you've gotten an award and you're not particularly happy. Maybe you thought that you had a strong claim. All hope is not lost. There is an avenue for you. Under Section 121 of the SMA 2013, any party to the tribunal proceedings may apply to the High Court to challenge a tribunal award on the grounds of a serious irregularity which has affected the tribunal award. So there's only one way you can do this, is by judicial review, which I will get into further in a bit. But if you intend on challenging a strata tribunal decision, it will require prompt action, of course, adherence to proper procedures, and it would be best definitely to seek legal advice in order to protect your rights and interests. So earlier, Carolyn mentioned that when you're filing a claim in the tribunal itself, it's quite informal compared to civil courts. So of course, people largely represent themselves. So when you're going to civil courts, it's not the same at all. And it is definitely not advisable that you take that on yourself. So for judicial review, like I said, this is the only way you can challenge a tribunal award at the High Court. And the judicial review process basically reviews the process in which decisions of the government or any government agencies, which can be challenged in the High Court by any persons that are affected. So as far as judicial review goes, it is more so concerned with the legality of the decision-making process of the executive and not so much with the merits of the decision. What this means is it doesn't matter whether or not you feel you have a strong case. It's about what has led up to this decision. Basically, the person making the decision in tribunal, of course, will be the tribunal chairman, the tribunal president, and that is what they're concerned with. not the facts of your case. So grounds of judicial review would include illegality, unreasonableness, irrationality, and of course, procedural impropriety, which is what I described earlier in the decision or the decision-making process. And the process of judicial review, it is quite complex, but to simplify it, I would say an applicant would have to obtain leave of court, which is essentially obtaining permission from court to apply for a judicial review application, and the application for leave must be made within 3 months. This is what I mean when I say that if you intend to challenge a tribunal decision, you're going to have to take prompt action. So this 3 months will start running from the date the decision was communicated to the applicant. So say you're in the tribunal and the chairman gives you a decision on 29th of December. So it will be 90 days from 29th of December. That is the last day for you to file. And the courts are very strict with these timelines. And very rarely do they allow, even if you're just 1 day late, very rarely do they allow it. So once you obtain leave or permission, application for judicial review will be heard on its merits in the presence of all parties. Grounds for challenging a tribunal award. So as I mentioned earlier, it has to be serious irregularities under Section 121 of the Strata Management Act 2012. So serious irregularities would include failure by the Strata Management Tribunal to comply with Section 113 of the Strata Management Act 2013, which is, of course, to act fairly and impartially as between the parties, giving each party reasonable opportunity of presenting his case and dealing with that of his opponent. So an example of this, of course, is quite self-explanatory, but the people making the decisions, they're human as well. Maybe they had a bad day. Maybe you called a witness, and as you were presenting, maybe you were interrupted and things like that. Just throwing out a couple of examples out there. And further serious irregularities would include the failure of the Strata Management Tribunal to deal with all relevant issues that were put to the tribunal. So, of course, everybody has the right to have a fair chance you have to have your day in court. No matter how long your facts are, you have to be given the opportunity to present yourself. And there must be uncertainty or ambiguity as to the effect of the tribunal award. So this is not so much about the decision-making process, it is about the wrongness of the decision itself. And powers of the High Court, so once you make a judicial review application, if the High Court is satisfied that there is a serious irregularity that affects a tribunal award, then the High Court will have the power to remit the tribunal award in whole or in part for reconsideration, or they can set aside the tribunal award completely. This will be dependent on whatever judge you get in the High Court. So just to give you a very brief, say, variety of case law, the first one I have here today will be Tam Sao Hong against Tribunal Pengurusan Strata, which is Strata Tribunal. Satu lagi would be the chairman that presided over his tribunal matter. So the applicant here was the chairman of a condominium management corporation who filed a complaint to the COB about the breach to the Strata Management and Maintenance Regulations 2015 by 4 parcel owners. These 4 owners were later elected as committee members. And the issue then remained unresolved, and the applicant had challenged the eligibility of some of the committee members in the annual general meeting. What happened here is basically these 4 parcel owners, they did not pay whatever charges they were supposed to pay. And when this happens, a person is not allowed to vote if you are in arrears. So that obviously wasn't the case here. Then parties of the AGM then referred the qualification issues to the Commissioner of Buildings, who then decided that out of the 7 elected members of the committee, only 4 of them could be on the new committee if they remedied any wrongdoing within a specified time. So this ties back to, I'm not going to get too much into it, but if you are in arrears and an AGM is coming up, there is a time frame for you to basically pay off all your debts, and then you can continue to vote. You don't have to wait till the next AGM, but your debts must be fully settled. So here, the chairman disputed that the 4 parcel owners had remedied their wrongdoing. We see this very often as well. Unit owners, they will try to claim that they have paid off their debts in various ways, be it by credit note, or they said that they settled off the debt with something else. So the chairman in this case had disputed it. But the Commissioner of Buildings, unfortunately, had confirmed their qualifications, so they were allowed to attend and then subsequently vote at the AGM itself. So the chairman then filed a claim in the Strata Management Tribunal seeking an order for the management corporation to comply with the rules in the regulations. The claim was then rejected on the basis that it had become academic, which in other words, it means it's useless. You have no cause of action anymore. because the 7 unit owners had already retired from their positions as committee members. So the applicant here then filed for a judicial review, citing that there were serious irregularities and non-compliance of the requirement to provide reasons for the decision. The High Court in this case was satisfied that there was a serious irregularity, which fell under Section 121 sub 3 sub B of the Strata Management Act 2013 specifically. And it was held by the High Court that the tribunal had failed to take into account relevant facts and misunderstood the facts and issues that were presented by the chairman. The decision of the tribunal was then set aside. The applicant's claim was then ordered to move back to the Strata Tribunal to be heard by a different chairman in the tribunal. The second case I have for you would be Perbadanan Pengurusan Sunrise Towers against Tribunal Pengurusan Strata and others. So the applicant here was an MC itself, a management corporation, which commenced an action directly in the Sessions Court against parcel owners for outstanding payment on charges like their maintenance fund, their sinking fund, their service charges, all those things. So the Sessions Court disallowed the applicant's claim, and then the applicant then appealed to the High Court, which then set aside the Sessions Court decision. So he had obtained confirmation basically that these people were in arrears and they did owe money. So based on this High Court decision from the High Court appeal, the applicant took this case back to the tribunal, and then they filed a tribunal claim against these parcel owners that were in arrears to recover any outstanding charges. So the tribunal then dismissed these claims against the parcel owners, and the applicant had filed a judicial review application at the High Court. If I'm not mistaken, in this case, the tribunal dismissed the claims because at the time they said that the management corporation did not have any standing to sue the parcel owners. Basically, they had no leg to stand on in order to claim these charges. But of course, with the coming into force of the SMA, things are different these days. So he filed a judicial review application, and the High Court then held that the management corporation had a statutory duty to collect maintenance charges that are in arrears. They are allowed and required to do whatever it takes to get this money back. And there was also a statutory duty which was inescapable of these parcel owners. As co-proprietors of a unit in the development itself, they had to pay their maintenance charges. It was further held that it was unjust for the parcel owners to enjoy the same facilities in the development as everybody else, all other paying proprietors, without them having paid their own maintenance charges. So the parcel owners in this case also admitted that they were liable to pay arrears in maintenance charges, and of course they couldn't get away with it. So the tribunal itself failed to consider all these relevant issues, and the tribunal award was later found to be irregular, and it was set aside completely. So the applicant's claim, just like the chairman in the previous case, it was ordered to be reheard by another president back at the Strata Tribunal. Another case I have for you is Law Hock Hua against PJ8 Joint Management Body. So the applicant here was a parcel owner of 3 different units in the development itself, the condo, and he was also a former treasurer of the joint management body of PJ8. And the applicant here filed a claim against the JMB, seeking to nullify resolutions that were passed by the JMB in order to revise service charges. So the JMB filed a defense and counterclaim to claim for shortfall of service charges, to prevent the applicant from participating, voting, or serving any committee-related activities. This is what I mentioned earlier. When you are in arrears, you can attend the AGM, but you cannot be a voting party. So it will be a waste of a vote lah. And the applicant's claim was eventually struck off because he had gone to the wrong tribunal for the hearing. I'd just like to make a quick note here. As I mentioned earlier, there's a tribunal at Putrajaya and there's another one at KL. It's near the Chase Perdana building. It is very easy to get these two mixed up. So if you do decide to file a claim in the tribunal, please make sure it's the correct tribunal. So the applicant here then applied to reinstate the claim, but he was denied of this opportunity. The JMB's counterclaim was also heard and dismissed, but for some reason, the tribunal chairman still ordered the applicant to pay 250,000 ringgit as well as cost of 8,000 ringgit to the JMB itself. So the applicant, of course, filed for judicial review in the High Court, citing that the tribunal itself had no jurisdiction to hear the JMB's counterclaim, because the JMB's counterclaim, if I'm not mistaken here, was over 300,000 ringgit. And as Carolyn mentioned earlier, they have a jurisdictional limit of 250,000 ringgit. So it related also, the cause of action itself was related to a breach of fiduciary duty, which the tribunal had no authority to decide on, respectfully. And it was held by the High Court that the tribunal's decision was indeed tainted by errors of law. It was irrational and there were serious irregularities. So the JMB's counterclaim, as I said earlier, it exceeded the tribunal's jurisdiction limit of 250,000 and was not supported by any evidence. I believe this is the final case I have for you, which is Commissioner of Buildings Hang Tua Jaya Municipal Council against a joint management body of Exora Apartments and another. So the first respondent in this case was the JMB of body of Exora Apartments, and they had applied to the Commissioner of Buildings for payment of allowances to some of the committee members of the JMB, like the president, treasurer, and all those things. So the COB eventually refused the applicant on the grounds that this application was not discussed nor put forward in any general meeting and was not made known to all parcel owners who had paid maintenance fees to the JMB. What happened here was basically when you live in a condo, you are required to pay all these maintenance fees. And when you make your payments, you are then entitled to vote in your AGMs and you have a voice. You get to decide how the money from the sinking fund is used, how the money from the maintenance funds are used. And if any sort of payments were to be made, you require the approval of all paying proprietors of the development itself. So the JMB in this case then filed a case at the tribunal to challenge the decision of the COB to allow for the payment of allowances to the committee members. Tribunal then set aside the Commissioner of Buildings decision and ordered that the JMB submit a new application to the Commissioner of Buildings in order to get their payment of allowances. The Commissioner of Buildings themselves, in this case, then filed a judicial review in the High Court. And the High Court held that even though the decision of a tribunal is said to be final, the decision, of course, is still subject to review by the court under Section 121 of the Strata Management Act 2013 and the inherent jurisdiction of the court to do justice. So I would say with a parting note, it is a very good place to start to file your claim. You can definitely settle your affairs there without spending too much money by going to the civil courts. But sometimes it's just human error. Sometimes chairmen get it wrong, and there is still an avenue for you to obtain the justice that you seek to achieve. So it was held here that the Commissioner of Buildings had no right to determine the payment of any expenditure because exercise of that power is subject to public scrutiny by the parcel owners. A general meeting is required to approve the payment of allowances in order to comply with public accountability as well as good corporate governance. That will be the conclusion of my talk today. And I think I'll give it back to Abraham.
Thank you, Jasmine, and also thank you, Carolyn, for the most wonderful and insightful talk. So now we will begin with our Q&A sessions. So I've seen in the Q&A box that there are quite a few questions posed by the attendees. So perhaps you'll answer the first one, which is posed by an anonymous attendee. I bought a unit from a developer and the defect liability period has expired in April 2019. Recently, I have detected leakings in the toilet area, upstairs tank area, etc. I've requested for the developer to repair, but they just ignore me. Can I claim under latent defect and file at the tribunal? Maybe perhaps Carolyn would like to answer the question.
Yeah, can. So this sounds to be an interfloor leakage issue where either the leakage is coming from common property or your upstairs unit. So in a situation like this, you've mentioned that you've passed the defect liability period, so your claim will not necessarily be against your developer. In this situation, it would either be against the upstairs unit or your management. We would actually advise in this kind of situations usually to not rush to the Strata Tribunal first, because you have to show that you have taken all other available steps first. And in this situation, the main steps would be to report it to your management. And then what your management will have to do is that they'll have to carry out an inspection to decide where this leakage is coming from, whether it's coming from the upstairs unit or whether it's coming from common property. Now, if it's coming from common property, the person responsible for fixing it would then be the management itself. If it's coming from the upstairs unit, the person responsible for fixing it would be the owner of the upstairs unit. In the event it's from the upstairs unit and the upstairs unit owner, for some reason or another, refuses to fix it or refuses to acknowledge that it's coming from their unit, the management can then take over fixing it, and then the cost of doing so, they can claim it from the upstairs unit itself. So to simplify the process here, report it to your management. Usually the management will handle it from there. If not, then only you can claim it in the Strata Tribunal. But in that situation, usually what our advice would be, or usually what we would say best thing to do, best practice here, maybe to get a plumber in or a technician in or whoever it is to verify for you where the leakage is coming from so that you know who to name as your particular respondent.
Thank you, Carolyn. Hope that answers the question. So moving on to the next question by Catherine Lee. The question is, say the building maintenance fee of a condominium unit rented by an owner to party A is in arrears. Can the owner of the unit bring such a case to the tribunal against the tenant, party A, as the tenant is the actual debtor and not the owner? The tenant resides in the building, enjoys the facilities maintained and managed by the building management, etc. Perhaps again we could get Carolyn to answer this question.
So this question is basically saying maintenance fees supposed to be paid for by the tenant. Since you as the tenant or I as the tenant enjoy the common facilities, the swimming pool, etc. But the management's claim at the end of the day will be against the owner or the proprietor, not the tenant. So that will be the landlord. Although the tenant is the one that enjoys it, the person responsible for paying the maintenance fees will still be the proprietor. Now, not paying your maintenance fees, let's say you are a landlord, you have a tenant in your unit, and you don't want to pay your maintenance fees, that will and can affect your tenant. Because in the event the management has already given you sufficient notice, etc., the next steps that they can take is they can block your access card, which is usually needed for things like your car park or to go up the lift to your unit, or they can restrict you from using common facilities. For some of the strata buildings nowadays, places like the pool, the gym, you need your access card to go in, and they can block that card, but they cannot stop you from entering into your unit. Now, if you are the tenant in that situation and your landlord refuses to pay, what you can do is actually check your tenancy agreement. Tenancy agreements are usually pretty standardized. So you check your tenancy agreement, and if there is a clause in there which says that which usually will say that your landlord as the proprietor is the one responsible to pay the maintenance fees, and they refuse to do, you can actually end your tenancy early on that basis. Thank you.
Thank you, Carolyn. Now we have another question from Terence Miranda. So if the COB doesn't take criminal action against the non-compliant party after the magistrate's court has recorded your case, can you apply to the court to cite the party for contempt of court and seek to jail the party? I believe Carolyn has worked hard to answer the past two questions, so maybe we could get Ms. Jasmine to answer this question.
Okay, sure. So if I'm taking your question correctly, in order to enforce any mandatory or prohibitory injunction orders that arise out of your award, committal proceedings for contempt of court can also be pursued. I hope that's the answer that you're looking for. I don't quite get your question actually.
And we have time for one more question from Cha An Lim. So for an Inca award from the GMB or default of an award by the GMB, after getting the court case registered and filing a complaint to the COB, is it at the discretion of the COB to decide whether to prosecute the JMB or not?
I'll take this one. No, it's not at the discretion of just the COB. You can file a complaint to the COB and they'll run their own independent investigation, but you yourself as the complainant, you can choose to apply for enforcement proceedings themselves. You don't need to wait for COB in order to take action against, in your case, a JMB, I believe. So in order to enforce any judgment debts arising from an award, then as I mentioned earlier, there were 5-6 different types of civil execution proceedings that you can take against the non-complying party. The COB has the discretion on whether they want to prosecute or not. If you want to wait for a COB and they later decide they don't want to prosecute, then you can take things into your own hands. It's fine. But the downside to this, which some people may see as a downside, you'd have to cover the cost yourself. Let's say the orders that you are seeking to get is for the benefit of the development as a whole. And if you were the only one that was pursuing this in the civil courts and you were bearing the cost all by yourself, maybe there will be a downside to you. That answers your question.
Thank you so much, Jasmine, for the wonderful answer that you gave. Now, before we officially end our talk, I have a few announcements to make. Firstly, if all of you enjoyed the talk and found today's talk insightful, please join us again for our upcoming talk entitled Applying for Planning Permission, Overcoming Approval Challenges in Project Development on the 3rd of April at 3 p.m. Moving on, also do join us for our upcoming MWKA Academy talk entitled Corporate Social Responsibility, Business and Human Rights on the 10th of May 2024 from 9:30 in the morning to 1:30 p.m. here in our own MWKA conference room with our consultant, Dato' Ma Weng Kwa himself as the speaker for this seminar. Now, this workshop will cover all of the essential elements of leading companies to seamlessly integrate ethical practices and translating them into heightened revenues, enhanced brand loyalty, and increased market positioning. Don't miss out on this opportunity to gain valuable insights and secure the early bird price by scanning the QR code on the screen or by clicking the link which is provided in the chat box. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. And thirdly, do follow or like our social media accounts. And fourthly, if you would like to speak with our lawyers, we offer a complimentary 30-minute consultation over the phone or over video conference. Please fill in the form on our website, and the link is also posted in the chat box below. And to our guests, thank you for joining us, and we hope you found today's session informative and useful. See you at our next talk.